I'm Kristen Osenga from the University of Richmond School of Law, and I'm going to break down the Supreme Court's opinion in Iancu versus Brunetti in just over 2 minutes. The issue in this case is whether the statutory provision in the Lanham Act that prohibits registration of immoral or scandalous trademarks violates the First Amendment. The trademark at issue is FUCT, a brand of edgy clothing. The Trademark Office denied registration of the mark based on a clause in Section 2 of the Lanham Act that bars immoral or scandalous marks. That phrase, immoral or scandalous, has been interpreted to mean shocking to the sense of truth, decency, and propriety, or offensive, or just plain vulgar. Justice Kagan, writing for the majority, framed the key question as whether the immoral or scandalous clause is viewpoint neutral or viewpoint based. Here, the court found the prohibition is clearly viewpoint based because it allows registration of marks that champion society's sense of rectitude and morality, but refuses marks that denigrate those concepts. If the statutory provision disfavors certain ideas but promotes others, that's the very definition of viewpoint based. The court provided some helpful examples, such as the rejection of marks that approve drug use, such as you can't spell healthcare without THC, but approving registration of marks that oppose drug use, say no to drugs. Or rejecting Madonna for wine because it may offend Christians, but allowing Praise the Lord for a board game. Because decisions are made based on the point of view the trademark represents, the statutory provision is presumptively unconstitutional. The government had no persuasive arguments to overcome the presumption, and so the court found the immoral and scandalous clause to be unconstitutional. Justice Alito wrote a concurrence, noting that a law banning speech deemed by government officials to be immoral or scandalous could easily be exploited for illegitimate ends. He also suggested that Congress could draft something narrower that only prohibited registration of words that are unnecessary for expressing ideas. Justices Roberts, Sotomayor, and Breyer wrote various opinions, concurring in part and dissenting in part, largely suggesting that the terms immoral or scandalous could be read more narrowly, and thus the provision would still be constitutional. One final point. Justice Sotomayor noted a fear for upcoming rush to register profane and obscene trademarks, but that's not how trademark law works. You can't just register any old word. It has to be used in commerce, and it has to be used to designate the source of a good or service. We're not going to see a wild stream of naughty word marks coming out of the Trademark Office, but we may see a few more clever craft brewers being able to get trademarks on IPA names that are double entendres. And that's the upshot of Iancu versus Brunetti.